This is our first PMA Academy session of the year. It's always one of my favorites. State of the Union address, sort of a thing, right? Really important for us as an industry to keep our pulse on like the larger publishing space and kind of what initiatives are happening around the globe, domestically here, of course, but internationally as well. So a couple of things on my end before I turn it over to our wonderful guests that are with us today. As you all know, we did announce our PMC dates. So just a reminder, those are October 3rd through the 5th this year. Really excited. The hotel information is also up on the website now. So if folks want to go ahead and book rooms and kind of, start planning travel, all of that is available for you to do at this point. We do have various other events coming up throughout the year. One of those is the in-person event in May. It's the first week of May, first Monday really of May. We'll be out in New York. So keep an eye out for further information on that. And then as you guys know, for our members, we do some networking stuff each month. We have one networking session next week. And then for our publisher members, we have some specific publisher meetings coming up, the first one being next month. So for those of you that are here that are not members, I will and have expressed interest in membership for the questionnaire and registration. I will reach out to you to make sure that you guys are on board if you'd like to be prior to our networking event next week. But other than that, take a look at the website for the additional events and some other information. We have a lot of stuff that we are working on at the PMA, a little bit too early to get into full details there, but more to come on that next month from us. So without further ado, I do want to briefly introduce our two guests that are with us today, Danielle Aguirre from the NMPA and John Phelan from the ICMP. We're going to start with Danielle for 20, 25, 30 minutes or so. I'm going to keep an eye on questions in the chat box. So if things come up that you guys have questions on, feel free to leave in the chat box or the Q&A. I'll keep an eye on both. And then Danielle will take questions towards the end of her address. And then we'll turn it over to Johnny to close us out for the day. So without further ado, Danielle, I will turn it over to you.
Great. Thanks so much, Morgan. I really appreciate you having me. I loved speaking to you guys. I wanted to talk a little bit about what is happening in the industry here in the US, what NMPA is focused on. We're going to talk a little bit about the Copyright Royalty Board, which just came out with some important decisions, focus a little bit on new technology because NMPA is really starting to push a focus on certain areas there. And then I'll end by talking a little bit about what we're doing in terms of enforcement these days and what we're looking at. And so I'm going to start with the Copyright Royalty Board. I think most of you know what the CRB is, but for those who don't, it is a 3-judge panel that sits here in DC. They have the authority to set the rates for mechanical royalties. So mechanicals being downloads, interactive streaming, physical, and they set rates once every 5 years, and they set the rates for the next 5-year period. And so we just began a 5-year period on January 1 of this year for what's called Phono Records 4 period. The CRB has recently had 2 proceedings before it, and for a variety of reasons I'll talk about, but Phono Records 3, which was the period of 2018 to 2022, and then, of course, Phono Records 4, which had to set the rates that started in January. And why? Why did it have two hearings going on at the exact same time to set the same rates for the same industry? Well, back in 2018, when we received a decision for the last proceeding, it was a great decision. We won an increase from a royalty rate of 10.5% to 15.1% at the end of the 5-year period. But the digital services for the interactive streaming part of this appealed that increase. And we have been in an appeal and then what's called a remand, where it goes up to an appellate court and then back to the CRB for now 5 years. And so there hasn't been a rate set for 5 years. And so how has everybody been getting paid? Well, in the interim, essentially what they did was say you can pay at the old rate. And what happened was that meant the lower rate of 10.5%. And that is what copyright owners have been receiving for the last probably 3.5 years since they came out with that decision, which of course is not the great increase we thought we were going to get. But after litigating this for a number of years, the good sign is it looks like the judges are going to uphold the higher rate of 15.1%. And what that means is that publishers, copyright owners will receive a retroactive payment to true them up for what was due to them during that period. And it may be in the hundreds of millions of dollars. I mean, it looks to us like it is. And so it's a real increase, it's real money. But there's a catch, which is that the CRB has still not issued its final decision. And we can't start to pay that money out. It's the MLC, the Mechanical Licensing Collective, that would. We can't do that until they issue a final decision. And so we are waiting for the Copyright Royalty Board to issue that final decision. That way we can start to ramp up to understand really what publishers are owed for this prior 5-year period. Even after we have that decision and we have a final rate, the digital services, and we're talking about Spotify, Pandora, Apple Music, Amazon, they still have at least 6 months to go back and true up those royalties so that they have time to actually figure out how much they owe now. So I would say stay tuned. This has been a long process, and hopefully it's coming to a close soon, and copyright owners will get what they're owed for the prior period. And then we have Phono 4, which I said that period just started on January 1. So what happened with Phono 4? Well, Phono 4, we started the proceeding back in, 2021 for rates to start this year. And thankfully, there's really 2 buckets that we look at mechanical rates in. And the first is interactive streaming, which we were just discussing. The second is downloads and physical product and ringtones, although they're not as popular anymore. And why do we do that? Well, downloads and physical product and ringtones, the party on the other side of us in the proceeding for those are the record labels, and have always been the record labels. For interactive streaming, it's the digital services. And so what NMPA did, we were about to go to the proceeding in September, and we entered into a settlement. First, I'll talk about the DSP settlement. We entered into 2 settlements. So both settlements for both sides of these rates raise the rates for copyright owners for the next 5 years. So really, really positive development. The headline of the DSP settlement, and we settled with Spotify, Apple, Pandora, Google, and Amazon, is that the headline rate will step up over the 5 years from 15.1% to 15.35%. It doesn't seem like a huge jump, but obviously when you're talking about billions of dollars being paid out in the industry each year, it's actually a fairly significant amount that will increase over 5 years. And it's also important because the 15.35% that publishers and copyright owners are getting is, as far as we know, the highest right now in the world for these kinds of rights. And so hopefully what we're hoping is, that this sets a precedent elsewhere and that rates start to inch up even more because we were able to get this increase here in the United States. So we've also have some other, it's a 3-pronged rate. So all of the prongs. So one of the prongs is a percentage of revenue, which we're talking about. One of the prongs is a percentage of what the record labels receive from those digital services. And why do we do that? Well, we're not in a free market. The mechanical license is a compulsory license. Copyright owners can't say no. Anyone who wants to take it, as long as they pay the rates that are set by the CRB, can take a license and use musical works. And so we like to try to get a piece of what the labels are getting from the services because they are in a free market here, and they can negotiate the rates for these types of platforms. And so it is the headline rate of the percentage of revenue, what we call it TCC, which is total content cost, which is the percentage of what the labels are getting, or there's a minima. And it's like a penny minima to ensure that the rate can't drop below a certain amount if for some reason they were to slash their prices or do something that significantly decreased the amount of royalties that they were paying. And so those three, it's a greater of formula, so it's a greater of the three, and those three make up what the mechanical royalty rate formula is under our settlement for phonorecords 4. The CRB approved that settlement. They approved it in December, and those rates went into effect January 1. And so for those of you who receive royalties from the Mechanical Licensing Collective, you should see an increase in your statements of account that you receive from the MLC. When you receive them, I believe it's April 15th, those royalties get paid out for the month of January. That'll be the first month that everybody will see the increase with respect to the rates. The second thing that we did was we settled with the record labels. We had originally settled with them at the rate that was the rate for the prior 5 years. But, you know, we are actually very grateful. A number of kind of grassroots songwriter groups spoke up. They became very public about the fact that, one, there's no consumer price index, there's no cost of living adjustment to that rate, and it's a penny rate. And two, it's been the same rate for a very long time. And even though downloads are declining and other physical product are declining, with the exception of vinyl, that rate should go up. We went back to the table with the record labels and we came back, and what we did was we raised the rate from 9.1 cents to 12 cents. And plus, in addition to that, there is a yearly cost of living adjustment. So that rate should hopefully continue to go up with the cost of living adjustment year to year. And that rate was also approved by the CRB and was put into place at the end of December. And so both of those settlements have led to new rates. They're now in place. DSPs were required to start paying at that rate on January 1. What have we learned about this process, though? One is the CRB is a broken process. It took us over 5 years to fight the appeal by the digital services. It took almost 2 years for the Copyright Royalty Board to get to a point where they're close to reaching a final decision on the Phonorecords 3 proceeding, and they still haven't. I think a next big push for the NMPA for this coming year on a policy front is going to be pushing for reform of the Copyright Royalty Board. And basically just fundamental things like more clearer definitions of when things are due and clearer definitions of when the CRB has to issue decisions so that they can't wait 2 years to issue a decision while songwriters and composers are waiting for their royalties. The other thing is ensuring there's funding for the CRB, which is, you guys are probably all lucky enough to not have to go there, which it is a courtroom, but it is essentially a glorified windowless conference room in the Library of Congress in Washington, D.C. And what we want is to give them more funding so that they can hire more clerks to help, that we can ensure that the best and most qualified judges are being appointed. And so that is going to be a really big focus for us in the new year. I did note, I know we're taking notes on what the questions are. Somebody asked, is the rate increase for mechanical only or performance? The way the rates work is the 15.1% is a combination of, it's the mechanical rate, but it is, what you do is you deduct the performance royalties out before you pay out the mechanical. And so this is mechanical raise, if your performance royalties were to stay the exact same, you would still get additional money, and that would be additional mechanical money. So that is essentially how the rate works. That is the copyright royalty board. I guess I will stop for a moment and just see if anybody, since I'm going to switch topics, if anybody has any questions on the CRB.
There was one question that came in through the Q&A, Danielle, about the retroactive payment from the DSPs. Will it be paid out in a lump sum or spread out? Do you know?
So I believe that they are required to pay it out in a lump sum with updated reporting from those usage periods. And so what the MLC would do is they would pay it to the Mechanical Licensing Collective, and then the Mechanical Licensing Collective would then distribute it to all of its copyright owners that are owed royalties. And it would come with updated reporting so that you could understand what changed and why it changed and how much more you're receiving for each period.
Perfect. And I just want to mention, this might be low hanging fruit, but since our group here is a little bit international, this is specific to US mechanicals, not the broadcast mechanicals you would find elsewhere. This is very specific to US streaming mechanicals. I just want to be very clear that that's what we're talking about here.
That is absolutely right. Somebody also asked, is there interest? I wish. I wish that the DSPs, after putting us through 5 years of litigating and many millions having to hire lawyers, would have to pay interest on this money. There is a late fee provision in Section 115, which is the mechanical section of the Copyright Act. We have thought about arguing that late fees are owed. It wouldn't be owed on the entire amount because they've paid at the 10.5 rate, but paid on whatever the true-up is. I'm not sure that the judges would agree with that because they're well within their rights to appeal. And so I think probably that wouldn't be the case, but I do wish that it was. I don't know if there are any other questions, Morgan, but if not, I might turn to our next.
Yeah, just a quick definition of headline rate and penny rate to clarify.
Yes, sorry. And it's a complicated rate structure. The headline rate is a percentage of the digital services revenue. So when I say 15.1%, each usage period, so each month, the service has to say, we made X amount in, if it's a subscription service, in subscriber revenue this month. If it's, an ad-supported platform, we made X amount in ads this month, and you guys get 15.1% of that to distribute to copyright owners based on the usage on the platform for that month.
Perfect. Okay.
The penny rate is truly exactly that. It is literally a penny rate. It attaches only to subscription services, right? Because you can't have a penny rate off of an ad-supported. There's a penny of what, right? But it's a penny rate would be, of the $9.99 subscription price, we receive 60 cents of that for every subscriber.
Perfect.
Is essentially how it works.
Perfect. Okay, good on questions, it seems, for this, so we can go ahead and move on to the next.
So the other thing I wanted to talk about, and I know it's on a lot of people's minds, is new technology. Where everyone's talking about things like blockchain and NFTs and AI generated music, and we have been very focused on that. But this year in particular, we are making it a priority at NMPA. We are looking really closely at platforms that embrace new technology and looking to see how they're using music, whether they're licensing, whether we think that the way that their functionality works, they are required to license. And two things I'm going to focus on are, the first are NFTs, and the second will be kind of AI platforms that generate music. And so with NFTs, we did a NPA did a one-page guidance on NFTs for our members last year. I'm happy to share it with Morgan, and she can distribute it to your membership as well. It's also on NMPA's website. So for those of you who'd like to get kind of a primer, like it's a 2-page, really simple, straightforward primer on NFTs. But essentially, NFTs operate on blockchain. Blockchain is essentially a digital ledger that is shared and contains transaction data, and it's distributed across a network of computers. And so essentially what happens with NFTs is they are unique, non-fungible tokens, right? So that's what an NFT is, a non-fungible token. And they are tokens that are associated with a specific, either digital or actually physical, it doesn't have to be digital, asset. The thing about NFTs that is unique is that they are not, let's say you have an NFT that is a token that shows that you're the owner of a video that was created by an artist that embeds, let's say a musical work and maybe audiovisual. The NFT itself and that digital asset, the video, don't go together. The digital, most times the digital assets and the physical assets live off of the platform that the NFT lives on. So the NFT really is it's almost like having a certificate of ownership, but it's digital. The US Copyright Office and the US Patent and Trademark Office are conducting a joint study on NFTs right now, which we think is great and very timely, although, I know crypto kind of fell off a cliff last year, so we're seeing a little bit less of the unbelievable pricing around NFTs. But we are submitting comments to the Copyright Office, and we are participating in the roundtable, and really, on behalf of musical work copyright owners, what we're saying is, here's how NFTs are currently used in the industry. What we really need are safeguards from the piracy. And one of the big issues around NFTs is you have a certificate of ownership. Once it's on the blockchain, that is very difficult to be changed. So if somebody is what they call minting an NFT, if they've done that in a way that creates it so that the owner of some sort of digital or physical asset is somebody else other than the real owner of the work, that's a problem. It's very hard to change that. The other problem is a lot of platforms that sell NFTs, they can monitor and regulate the NFTs on their platform, but once somebody buys them and takes them off the platform or sells them again, they lose control and they can't follow it. So even though you have a certificate of ownership, or even though the copyright owner may have had an agreement with the NFT platform, I'm still going to get royalties for this, you can't really track it after it's gone past an owner or two. And so it's very, very difficult to keep track of where people are using musical works in a way that is not licensed, and especially where they're not paying for that use. And so we have started to look at NFT platforms very closely. We have a list of who we consider kind of are the biggest problems on the platform, on the web, because they're creating NFTs and they're using digital assets in a way that's either unlicensed or kind of really not well tracked, not a great operation, and there are unfortunately a lot of them. And so we're looking at that really closely. And one of the issues is really copyright law doesn't, like all technology, is changing faster than our copyright laws. And the Digital Millennium Copyright Act, the DMCA, really can't address this kind of infringement. It doesn't really apply to what these NFT platforms are doing or what subsequent owners of those digital assets and the NFTs are doing. And so part of what we're trying to do is figure out how to best address where and how to go after these kinds of platforms that are clearly not good actors and are not paying for the musical works that are being used. And so that is NFTs. The other and a big thing that we're focused on this year is AI platforms. And I know if you haven't been on ChatGPT, you should go on ChatGPT. It's unbelievable. It does everything. It's actually fascinating just to sit there and type in different commands, and it will just create things for you. But AI is really right. Artificial intelligence. It simulates human intelligence using machines and algorithms, and basically being trained to learn either by by inputs that it receives from the person who's creating the AI, or by data. And a lot of times that data is massive amounts of music catalogs, massive. And there are two issues here. One is a lot of these AI platforms, like I just mentioned, ChatGPT, there's others I'll mention, Jukebox, others, they are using all of our music catalogs and they're inputting them and ingesting them into their AI platform in massive scales in order to teach the AI platform. And for those of you based in the UK, you know this is a massive issue because the UK is pushing forward, and I don't, maybe Johnny will talk to this, an exception to that being an issue when somebody ingests a lot of data and text and data information in order to train kind of an AI or machine learning platform. So that's one issue, right? Is what they're doing when they ingest the information copyright infringement? And then the other issue is the output. And the output is unlimited, right? I mean, if any of you have used what's called ChatGPT or Jukebox, these platforms enable you to do unbelievable things. And this is the thing. Some of it is good, right? I mean, we are working with a company right now that is using an AI, generated technology in order to build an ability to identify cover songs, which really has always been an issue for us, on the internet. And if they are able to do that, this is a huge breakthrough for us because it enables us to better identify where people are covering other people's works in a way that's infringing. And it's also, many of you may even use kind of AI platforms as a tool for composers or artists when you're developing your music. But the infringement cases are like really, really broad. And one of this is, are they creating unauthorized derivative works, right? They're trained on copyrighted musical works and lyrics and melody from those works, and then they are spitting back out upon command, sometimes new lyrics to songs, but in the style of somebody, style of Beyonce, style of Taylor Swift, style of Bob Dylan. Sometimes they're using some of their lyrics to create a new song that is combined with new lyrics. They're also doing that often with, if you go to AI Jukebox, you can actually ask them to write a song about something that's new, but in the style of Bob Dylan, and they are imitating Bob Dylan to the point where it's almost the same voice as Bob Dylan. And so there are a lot of issues here that we're still just starting to look at. But that will be a big focus for us this year. And I will say, look, one of the issues that we have to, copyright infringement or not aside, that we have to address as an industry is this is going to compete with our market, with our commercial music market for lyrics and melodies that are created by creators in the US, right? So AI generated music may be cheaper to create. You don't need licenses most times because it's not copyrightable at this point. We are tracking a number of AI platforms who are promoting their ability to quickly create music and soundtracks for a wide range of applications, podcasts, ads, movies, video games, in different genres and styles, and kind of imitating actual creators. And really, this is right. This could be a big issue if it's not on your radar already for production music creators, right? I mean, one of the platforms we're looking at even says this AI music generator allows you to compose music for any video or game, and it comes with a royalty-free music generator to avoid any issues with licensing. And that's a problem, That's a really big problem, right? If somebody can go to Amper Music or one of these other platforms and create a 30-second clip of music that they can use in their game or they can use in their ad, and they don't have to license that music, it's going to start to take away from our. It's going to be competition, and so that is something we're looking at as well. I mean, already on Spotify, you can go and look up. There's entire playlists that are just AI generated music playlists. So that's another thing we're really looking at. One of the big ones, OpenAI, which is owned by Elon Musk, that's who owns and has created the Chat GPT, which I think thank you whoever shared that in the comments. Appreciate it. And so we are looking really closely at those and how they are using and creating music, especially, and whether that's something that we need to challenge and enforce for our members. And then I know I'm a little bit late. I'll just say a couple of notes on our enforcement, which is happening right now, which is Twitter, yet another thing owned by Elon Musk. I see a pattern here. We have been engaged in a pretty aggressive takedown program on Twitter for the last year. They are hiding behind the DMCA and they have refused to license music. But we have found almost 250,000 infringements reported, and that's only using 2,000 musical works. And we found almost 1,000 repeat infringers. That is people who have been noticed for their infringement and for their posting of unlicensed music over 6 times. So infringement is rampant on that platform. We are looking really closely at that. And the other thing is we're looking at the app stores, the Apple and the Google app stores. We have found tons of apps, almost 70 at this point, that were using music illegally. And we've been able to remove 6 already. We forced another 20 to remove all of their infringing functionality or content. And we have 9 that have improved their DMCA policies. And we're continue to work with Apple and Google. And then I will just note, because I know this is a really big issue, and I'll thank Adam Taylor, who we talk a lot, and I will say he's a great champion for you guys as the chair of your board, because he talks to me a lot about what your priorities are. So it really helps us to focus. But on the audiovisual streaming services efforts to upend how you guys are paid and compensated for your work by pushing kind of the buyout model that buys out rights completely. We've looked at it. We understand that kind of in this model, it prevents composers from receiving downstream performance royalties. Oftentimes, it circumvents the PROs, which obviously otherwise could negotiate rates. We are a little bit constrained as a trade association. These are direct market deals. And so we can't get too involved in jumping into people's deals. But look, we understand the impact that this has had, and we have, when we're been able to speak up about it and even address this directly with certain platforms and services, and we will continue to do that. So I urge you to continue to bring issues to our attention, and we will engage where we can, because we want to help to the extent we can. And so I will say, sorry I ran a few minutes late, Morgan, but if anybody has any questions to kind of wrap up, those are kind of my highlights for January 2023.
Thank you, Danielle. I really appreciate it. I will note too, Danielle touched on it, right? The legal, the copyright law, like a lot of these things, all of the law things are very slow moving, right? So even as AI develops, I know that the NMPA members are on DCC calls. Like it's a very active conversation, both on a domestic level legislatively and also international level legislatively. So a lot of these things that are stressors and headaches and tough now, some of them I imagine will continue to be tough through the years, but some of them will ease. That's my gut. That's kind of what I'm seeing and how it's kind of played out so far. And I know, Danielle, there are a few lawsuits, right? A few litigation things happening in the AI space. I'm sure that's something that you guys are watching as well,
Yes.
pending the results of that litigation and kind of how that stuff goes. So
Absolutely, absolutely. A number of them, including whether you can copyright AI works, which will be, I mean, that's really interesting, right? So somebody's challenging that as well. So we're
yeah.
watching it. We're watching it closely.
And same. And we work with the NMPA and others on all of these. So as you guys have issues or things that come up, feel free to reach out to me. Any publishers that are not members of the NMPA that are on here, please, please, please head to NMPA and talk to them about joining. Really important that we all work on this stuff together as, you know, tech changes and advances much more quickly than our law does. So thank you, Danielle. We really, really, really appreciate it. Thank you for your time. You're
Yeah,
welcome
thank you guys. I
to
always
jump
love
off.
talking to you all.
We really appreciate it. You're welcome to jump off, and we'll bring Johnny in, and we'll turn it over to Johnny for our international update.
Thanks a million, Morgan, and good morning to everyone there from a very rainy and cold London. My name is John Phelan. I'm the Director General at ICMP, which is the International Confederation of Music Publishers. And we just are delighted to be here today to give you a little bit of an introduction to who we are, what we do, and maybe a little bit of a whistle-stop tour of some of the big international themes that we're seeing at the moment. Before I do that, maybe I just want to say a big shout out to Danielle and to all of the team at the NMPA. We have a pretty good idea of how hard the work it is that they do, and some of the achievements they've brought in for the US industry over the last year are really quite extraordinary. So you don't hear it enough, Danielle, and we only just want to say an extraordinary thank you and well done to all the great work that you're continuing to do for all of us.
Thanks, Johnny.
So just with a little bit of an introduction, if I can, some of you may not have heard of ICMP. It is the global trade body for the music publishing industry. So essentially, it's you can think of it like a mud flap for the music industry. Wherever there are problems, our job is to go there and to try and fix them. That breaks down into a number of different areas, principally legislation and law reform. As Danielle has mentioned, there's been a lot of legislative reform in the US, which has directly affected the music industry. And we see that around the world, of course, so that's a big part of our job. A second big area, of course, is in terms of CMO and society relations and making sure that we're driving efficiency and transparency and distributions for music publishers. And thirdly, then just information exchange and technical expertise. So some of the themes that Danielle mentioned, such as artificial intelligence, live streaming during COVID, breakthrough new technologies. Our job is to basically get briefings to all of ICMP members as to their implications. So that's just basically the basic breakdown of what we do. And I'd just like to talk a little bit about who we represent, always very important to clarify. And so ICMP is representing today a digital music market of more than 100 million music tracks, extraordinary amount of repertoire. And the industry today is licensing just over 800 different DSPs. So digital is really driving the industry. We represent MPAs, as we call them, which are music publisher associations or national trade bodies in 76 different countries on 6 continents. And we also represent the majors and several hundred indies as well too. So that all aggregates up to the more than 90% of the 100 million tracks that I mentioned. So how do we structure our work? Well, first of all, as you can see here on the left-hand side, we basically look at big focal areas for the industry in terms of expert groups. So we have a blend of top experts from across our company members who sit on these groups of legal, outreach, industry metrics, best practices, all of these different areas, and they meet on a monthly basis to tackle the issues for the industry, feed that into ICMP, and then we take that to governments and CMOs as necessary. A second big part of our structure are our global regional groups. It's very hard to keep track of 76 different national MPAs. So what we've done in 2022 is structure those into these regional groups, which makes a lot more sense, particularly in terms of the ways the companies are structured in today's globalized market. So we have North America, Latin America, Africa, Europe, and the 3 A's of Australasia and Asia. And those regional groups gather all of our company members and again, feed in their regional issues to us. We, of course, have a governing board, and that board is 50-50 represented of several senior executives across majors and indies. You can see here the full suite of who they are, some very familiar names, I'm sure. And of course, Ralph Peer from the US, alongside Kathy Marsh at the MPA USA. And then the other 50%, apart from our national groups, are the companies, as you can see here. So that's just really a breakout of our structure. This is, as you can see, the areas and the ways in which we work. And I just wanted to give some headline figures about what we're seeing within the value of the music industry as of end year 2021, which the latest data is in for. We're still crunching some numbers for 2022, of course. And, you know, I think there's a lot of things to be positive about. If we really look at the industry in 2001, you're talking about a global value of music copyright, which is in around 28 billion US dollars. Today, in fact, actually end of year 21, that has risen to 39.6 billion. And as you can see here, the value of publishing is making up a large chunk of that as well too. The value of and the proportion of publisher value within the overall music industry valuation and revenue is really growing. So you can really see the extraordinary recovery that's happening after about 16 years of digital disruption. A large part of that is down to law reform legislation, the famous value gap being resolved. And I'll talk about how that was resolved in just a moment. But as I say, you can be positive about a lot of things here. Publishing today is at 13.5 billion. So one thing I wanted to talk a little bit is about the day-to-day work. At a global trade body, it can sometimes be obscure to our member companies as to what actually the work entails. And as I mentioned earlier, this is the kind of broad breakdown. Legislative reform is key. CMO issues, I've mentioned, is also key. Some of you will be very familiar with examples like La Rueda, which was the wheel, which was essentially a systemized fraudulent campaign in Spain between one of the public broadcasters who was skewing the music being played at midnight to 6 a.m. back towards the CMO in order to basically spin the wheel and distort the royalties going back to the industry. And so therefore ICMP stepped in officially with the government in order to tackle that issue. And that's the kind of thing that we are doing on behalf of our members across the world, frankly. Those issues are various. For example, in Turkey, we've just negotiated a joint licensing and distribution agreement between the two CMOs operating there. Those negotiations had broken down for many years. And so that's part of the role that we step in to resolve. We do a lot of institutional representation, so bringing the voice of the music publishing industry to the World Intellectual Property Organization, the European Union Intellectual Property Office, and all of the different various international key institutions where it's essential to fight for better copyright. So as of today, in terms of our law reforms, you can see here the sheer scale of the numbers of law reforms that we have completed in 2022. 72 different national governments we've been liaising with in great detail to strengthen copyright protection across these countries. And as of mid-Jan today, we're currently active in 23 different countries around the world in terms of trying to drive up copyright protection. So some specific examples I thought might be of interest today. China, a massive emerging market for the music industry. As of 2022, there's a new very large civil code on the books, and within that civil code is a revision and reform of copyright. And I'm glad to say that there's actually been some incremental, very positive change in terms of copyright protection, recognition of copyright, in what traditionally has been a very much a hotspot for copyright infringement and commercial scale copyright infringement, in fact, non-recognition essentially of the concept. And so there's a lot to be positive about there. How that's getting done is actually often to do with trade talks. So how governments such as the US negotiate trade policy with China often involves a copyright element. And that's where we insert ourselves there to try and make sure that those trade deals between the Biden administration and the Chinese authorities is making sure that copyright is increasing. Just moving on to India, another extraordinary market, a completely unique market. There are 1.2 billion people in India. Let that sink in for a second. There's 600 million people of 26 years and younger. India has the lowest commercial retail mobile data rates in the world. Most people have a device. And so there's an extraordinarily broad and massive scale music market there. The biggest issue is the fact that the commercial broadcasters and the DSPs don't take a license for music publishing rights. And that's been traditional inverted commas for decades. In early 2022, we finally got the Indian government to recognize that those licenses should be in place. So that's a real game changer for that particular marketplace. And that really matters when you think of the fact that in India, the 3 local DSPs, Ghana, JioSaavn, and Wink, between them have almost 1 billion paid subscribers. 1 billion. So that's really showing the need to get those licenses in place and to make sure that reform is suitably done. A lot of other big issues like statutory licensing. Spotify famously launched in India without Warner Chappell, without permission from Warner Chappell for use of their works. ICMP stepped in to make sure that that statutory licensing was not applicable or open to Spotify to resolve that issue. Safe harbor, law reform, copyright term, these are kinds of very common issues that we face as a trade body to try and make sure that we fix in India and similar markets. Looking at South Africa, on the table at the moment are 2 very large pieces of legislation of copyright reform. And basically in there, you've got a nightmare list of safe harbor provisions, massive restrictions in terms of writer mandates, reduction of copyright term from 50 years to 20 years, et cetera, et cetera. So what we're trying to do there is directly liaise with the South African government to make sure that those are massively changed. And thankfully, the US trade representative authorities, they've been stepping in very helpfully to support our asks to make sure that the South African president doesn't proceed with the legislation as it's currently planned. A big work on there. Moving, of course, to the States, we're delighted to see the incredible work done by the NMPA last year. Danielle has spoken already about the CRB4 rates, which is really amazing, 44.5% rate increase. And that just goes to show the worth of trade body work. Moving on, trade policy again in Canada. Maybe people haven't been following trade policy so closely, but it really matters. We've had the copyright term extension within that trade deal between the US and the Canadian government and Mexico, and that has extended copyright term in Canada from life plus 50 to life plus 70. That was put in place formally as of November last year. Another massive win there for the Canadian colleagues. And there are discussions, of course, in Canada in terms of safe harbor, whether that gets embedded in their copyright law further. And that's a very important forum for us to be involved in to make sure that that safe harbor is not extended in what is a huge market worldwide. Moving on. Just looking to Mexico, they do not have a private copy levy system. We're pretty cautiously optimistic that in that marketplace, one of the fastest growing in the world, that there will be a PCL system hopefully by 2023. So we're working very closely with the Mexican government and senators to ensure that's put in place. And we're also trying to counter those people who are trying to reduce what is the world's longest term of copyright protection. Mexico currently has an extraordinary life plus 110 years. So people are trying to reduce that. Brazil, we've just seen the outgoing President Bolsonaro trying to bring in some presidential provisions which would give licensing exemptions. That's a common challenge that we find around the world. Authorities and governments bringing in licensing exemptions, which would basically give carte blanche for general performance licensing for hostelries to not take full and fair licenses. So we're pushing back very strongly there in Brazil to make sure that doesn't come to pass. Why? Because it's one of the world's fastest growing markets again, LATAM. The most streamed artist during COVID in terms of live streaming during lockdown was indeed Brazilian. So it just goes to show the scale and size of that marketplace. I want to talk a little bit more about some of the issues that we're seeing here in India, simply as it is so extraordinarily large and has some very particular features. When we talk about copyright protection and copyright enforcement, really that's a solution, of course, to a problem. So we look at the kinds of problems that we face. Look at this marketplace in here in India. As I mentioned, you've got predictions of the third largest economy by 2030. You've got an extraordinarily young population, 65% of whom are 35 or younger, the lowest mobile data retail rates in the world, but people are massively listening to music. So 21.5 hours is the average weekly music consumption. That's really high compared to a global average. 86% of Indians, that's 1.2 billion Indians, listen to audio streaming services, most of which are unlicensed. And 91% of those billion people listen to the radio. Again, the radio stations don't have licenses in place. So as you can see, that's the challenge there, is to try and take those problems, get better copyright protection in place into the legislation, so that that incredible marketplace of people who are clearly massive fans of music, that can be fully and fairly licensed, and so that Indian and international companies can get rightly paid for their work. I just wanted to touch on briefly some topics which may be more familiar for those of you who've been following these over the years. There's the EU Copyright Directive, the specific provision, Article 17, which has been the subject of a lot of news coverage, speculation. It was an extraordinary campaign, Article 17. Just before the European Parliament vote, 100,000 German people marched in the streets against the Copyright Directive to protest against it in various cities. Google sent 8 million emails to the European Parliament in the months before the vote in order to make sure it didn't happen. They spent £37 million in their lobby campaign in Brussels against the European Parliament in order to bring the Copyright Directive off the table. And that goes to show the scale and the sophistication of what trade bodies are up against in order to try and get good copyright protection onto the table and into legislation. Why does it matter? Well, as you can see here, streaming video on demand services are now 58% of the entire internet traffic volume. That just goes to show the scale of SVOD provision. And if there's not a full and fair license in place, then we've got serious problems within that marketplace. So Article 17 sought to solve that, and it solved it by clarifying that services such as YouTube, Twitch, Twitter, LinkedIn, TikTok, what we call user uploaded content sites, that they can no longer have a safe harbor. They must take a license, a full and fair license for all of the music that they have in their services. And that's a world first. So finally, the safe harbor has been knocked on the head for those kinds of services by the EU Copyright Directive. But that first pillar of platform liability is not the only thing that's in there for international companies. And bear in mind, any American company which is operating in Europe or has rights in Europe, of course, avail of these kinds of benefits and protections under Article 17. But indeed, there are further pillars. Rights enforcement. Article 17 has the world's first ever preventative blocking and notice and stay down of unlicensed music. So if you look around TikTok or Facebook and you see the extraordinary scale of the problems of lack of reporting, unlicensed music, in Europe, now we have notice and stay down. All you have to do is notify the work, the writer, any of the unique identifiers, any of the ISWC codes, and then that service is obliged by law to make sure that work does not appear in their service, or indeed if it gets up there, that it's noticed and stays down, not notice and take down. So that's an extraordinary achievement within Article 17. There are also transparency obligations. I'm constantly telling our member companies about how this is actually the biggest change of Article 17. Now these services are obliged to report, quote unquote, to the highest industry standards, their usage reports back to rights holders as to what's happening on their service. And anyone's had a route around Content ID or the content management systems of Facebook will know how big of a problem the transparency and reporting is. And finally, Article 17 clarifies that that needs to be massively improved. And finally, within Article 17, the EU as an entity, so as a grouping of 27 individual countries, now makes the provisions of Article 17 that a part of their trade policy. So when the EU is negotiating with China, with India, indeed with Canada, it must then say that these provisions of liability, rights enforcement, and transparency should be exported through trade policy to these other markets that I've mentioned. As you can see here, just in this little GIF, the current status is that we have to transpose the EU law through to individual national countries, the 27 countries in Europe. So what ICMP is doing on a day-to-day basis is getting involved with those 27 governments to transport the law into national law. And as we stand today, there are 5 remaining countries, simply Poland, Portugal, Finland, Latvia, and Bulgaria. And the other 22 European countries have now put in place the EU Copyright Directive into their national law. So we're really close to the finishing line. What does this all mean? Well, it really matters in terms of dollars and cents. If we look at 2013 in terms of YouTube's payments to the music industry, they're sitting just over $1.5 billion US in terms of revenue turned back to the industry. If we look at 2019, a full 6 years later, wasn't much better, just over 3. Post Article 17 and post the European Copyright Directive, as of end year 2022, YouTube are now paying the music industry north of 6.5 billion US dollars. That's a big jump. And a big part of the corroborative effect of that valuation is the solving of the value gap through Article 17. And then you've got the further benefits of copyright enforcement, transparency, etc. So the Copyright Directive in Europe isn't the only thing we're working on. In fact, on the table, the European Union has been emboldened by Article 17 and is putting on the table what they're calling the Digital Services Act. This is essentially the next step of the Copyright Directive. And this new law is coming into place in February. And as you can see here, it's been passed by the European Parliament, the Commission, and all of these international institutions in Europe. Basically, what they're trying to do is tackle the companies in the corner, as you can see, Apple App Store, Google Play Store, Meta, Amazon, eBay, and to put new rules in place in terms of how those platforms operate. So if you think about the Section 230 and DMCMA challenges in the US, the challenge here within Europe is trying to address those kinds of issues through the Digital Services Act. So basically the DSA, as it's called, divides up the types of services into 5 types. You've got hosting services, online platforms, etc., marketplaces, very large online platforms, very large online search engines. And depending on the type of digital category or service, you have different obligations under the DSA. And what that means is essentially lots of practices are banned or obliged. And as you can see here, I hope you can see my screen. I'm happy to share this afterwards. You've got a long list of transparency obligations, pre-market checks, new advertising transparency obligations, which fall under a sliding scale for the different types of services for the DSA. And that's, you can really see the European Union being emboldened by Article 17 and pushing forwards to increase these rules, which is only a very welcome development. So that's been our latest negotiating activity in Europe. So why does it all really matter for music? A lot of this might seem obscure or overly complex or even just in the periphery of what we do. At the end of the day, what the NMPA is doing and what other trade bodies are doing is on behalf of all songwriters and writers and rights holders. If you get a positive change, or indeed if you get a risk in a government policy, it affects everybody. And that's just the fundamental need for this kind of work. If you get a good positive change, such as a copyright term extension in Canada or in New Zealand, as was this year, it affects the entire sector. And so that's why we do what we do. Just here is a little recap of some of our members, companies, national members associations, and they come to us and basically say, we've got an issue in Nigeria, we've got an issue in Brazil, we've got an issue in Spain, and that's why we do our work, because if we do that, everyone in those national markets benefits. That's 90% of the sector, as a quick reminder. And so therefore, I've just finished my conclusion. I know I've covered a lot of ground, a little bit of a skim, also imbued with an Irish accent, which I hope wasn't too impenetrable as well too. But I'd be very happy to answer any questions if anyone has any. But otherwise, a real pleasure to be here and to give you a little bit of an intro to what we do. All the usual platforms, shameless plug, Twitter, Instagram, Facebook, if you can follow us and follow what we do, that would be very welcome. But thanks for your time for the meantime.
Thank you, Johnny. Really appreciate you being here. I want to reiterate, right, when we bring all of you guys together in meetings like this, and we have Danielle and Johnny join us, what Johnny just said was absolutely it. As these legislative things happen, we are really in the midst of like legislative changes all over the world, right? So what happens in one territory very directly impacts other territories, and things like, you know, copyright, like rolling back the copyright years from 50 to 20, all of these things are on the table. And the last thing that we want is for, you know, it to get picked up somewhere, then the US runs with it, and then we're all kind of ass out. So really, really, really important that we're all tuned in, you know, globally to what's going on in copyright. I know this is a very high level discussion, much more focused in the larger publishing space, right? It all directly relates and funnels back into production music as we operate in publishing. So really important that we all know what's going on here. I did get one question from Ron. Maybe you can answer quickly. Apparently, some countries in Latin America, Peru, Argentina, seem to believe they do not need to pay for music used in news programs, even if the music is synced with the news programs. Any insight on that? And is it something that you're watching and or working on?
Yeah, thanks very much, Morgan. Thanks, Ron. Indeed, we see these kinds of issues all the time, and people not wanting to pay, and it comes down to a lot of different things. It can be just a percentage mismatch in terms of the claiming or underclaiming, or it can be indeed be disputes of the rights. And so in Latam, as you mentioned, there are indeed users who sometimes deny the how can I say, the viability of the sync right. In the US, the sync right is really a cornerstone of the marketplace. That's not the same around the rest of the world. National legislation from country to country, it's really important to look at that first and see if the sync right is recognized. In many places, it's more of a business custom. So therefore, different countries rely upon different rights to leverage as really driving the market. So Danielle has spoken about how in the US, the mechanical right is set by law and set by courts, by the CRB. The sync right is obviously more viable. That is tipped on its head in lots of other countries. The point being that use of music in any form of broadcast where is the use of exclusive rights, of course. So fundamentally, there can be no way in which a broadcast user, either public or private, can be using music, no matter what the snippet, unless it falls directly under copyright exception without taking a full and fair license. So where there are disputes about that from users, it's not uncommon, but it's often totally unfounded. So be very happy to take that offline, Ron, with you or any of your colleagues. If you're seeing those issues, we have national groups in all of those territories, and we can touch base with those on the specific issue. And at the end of the day, approach those broadcasters and make sure they get the license in place. Thanks, Ron. I see your message.
Amazing. All right. Well, thank you again, Johnny, for being here. Thank you for all the insight. Thank you to everyone on this meeting that joined us. We really appreciate you being here. If anyone needs to dive deeper into anything at all or wants to touch base with Johnny offline or me or Danielle or whatever the case may be, like I said, I know this was a lot. And some of it goes over my head as well. So if anyone needs clarification and wants to chat a bit more, please reach out, please email me. Happy to set some time up to dive deeper with you. Appreciate all of you being here. Thank you and have a wonderful rest of your week.